What limits Parliament's power to change the Constitution? This question sounds simple. Article 368, which governs constitutional amendments, says Parliament can amend any provision of the Constitution with a special majority. That seems to answer it. But then a harder question arises. Can Parliament use Article 368 to amend away the Constitution itself? Can it pass an amendment removing all fundamental rights? Abolishing judicial review? Converting India from a democracy to a one-party state? Article 368 says Parliament can amend any provision. Does that mean literally any provision without any limit? The answer that the Supreme Court gave in 1973, after decades of constitutional controversy, is what we call the Basic Structure Doctrine, and it is India's single most important contribution to constitutional law globally. Let me tell you how it evolved. In the Choudhary Prasad case of 1951, the Supreme Court held that Parliament can amend fundamental rights. Constitutional amendments are not laws under Article 13 and are not limited by it. In the Golanath case of 1967, an 11-judge bench reversed this. It held that Parliament cannot amend fundamental rights at all. FRs are transcendental, beyond Parliament's amending power. Parliament immediately responded with the 24th Amendment of 1971, adding Article 13 Clause 4 to clarify that constitutional amendments are not laws, and explicitly stating that Parliament can amend any provision, including fundamental rights. Then came the Kesavananda Bharti case of 1973. A 13-judge bench, the largest in the Supreme Court's history, was convened to settle this question. The case was decided by a 7-6 majority. The judgment runs to hundreds of pages. The court agreed that Parliament can amend any provision of the Constitution, including fundamental rights. It overruled Golanath. Parliament does have the power to amend FRs. But then the crucial holding. Parliament cannot amend the Constitution in a way that destroys or abrogates its basic structure. The basic structure is not defined in the Constitution. It is a judge-made doctrine. The court said that the Constitution has certain essential features that give it its identity. These features are the soul of the Constitution. Parliament can renovate the constitutional building but cannot demolish its foundations. What are these essential features? The court did not give an exhaustive list. Different judges named different elements. But from Kesavananda and subsequent cases, the recognized elements include supremacy of the Constitution, the republican and democratic form of government, the secular character, the federal character, separation of powers, judicial review, free and fair elections, the independence of the judiciary, unity and integrity of the nation, the rule of law, parliamentary system of government, the harmony between FRs and DPSBs as established in Minerva Mills, and the limited amending power of Parliament itself. The doctrine was first applied in the Indira Gandhi versus Raj Narayan case of 1975. The 39th Amendment had tried to immunize the Prime Minister's election from judicial review. The court struck it down. Free and fair elections and judicial review are both basic structure elements. In Minerva Mills of 1980, the court struck down the 42nd Amendment's attempt to give absolute supremacy to DPSBs over FRs. The balance between them is basic structure. In the IR Qualo versus State of Tamil Nadu case of 2007, the court held that laws placed in the 9th schedule after the 24th of April 1973, which is the date of the Kesavananda judgment, can be challenged if they violate the basic structure. In the National Judicial Appointments Commission case of 2015, the court struck down the 99th Amendment that had tried to replace the collegium system with a new Judicial Appointments Commission. The court held that judicial independence, a component of basic structure, would be compromised. The critics of the basic structure doctrine argue that it is countermajoritarian. An unelected Supreme Court can permanently block any constitutional amendment. No matter how large the parliamentary majority, if 5 judges decide it violates a concept that is not even written in the Constitution. The defenders argue it is the Constitution's immune system. Without it, any powerful government with the required majority could dismantle democracy through legitimate constitutional amendments. The basic structure doctrine is what ensures that cannot happen. India's basic structure doctrine has been adopted or cited in constitutional courts in Bangladesh, Kenya, Uganda, Pakistan, Malaysia, and several other countries. It is arguably the most significant judicial contribution to global constitutional theory. For your exam, You must know the evolution. Shankari Prasad, Golok Nath, 24th Amendment, Kesavananda Bharati, first application in Indira Gandhi versus Raj Narain, Minerva Mills, IR Qualo, and the NJC case. You must know the established elements of basic structure. And you must know that the list is not closed. The court may add more elements. Now your MCQ. The basic structure doctrine was established in which case? And what was the core holding? Option 1. Golok Nath versus State of Punjab 1967, which held that Parliament cannot amend fundamental rights at all. Option 2. Kesavananda Bharati versus State of Kerala 1973, which held that Parliament can amend fundamental rights but cannot destroy the basic structure of the Constitution. Option 3. Minerva Mills versus Union of India 1980, which first created the basic structure doctrine. Option 4. Indira Gandhi versus Raj Narain 1975, where the doctrine was first applied to strike down a constitutional amendment. Think carefully. The correct answer is option 2. The basic structure doctrine was established by the Kesavananda Bharati case of 1973. A 13-judge bench by 7-6 majority held that Parliament can amend the Constitution, including fundamental rights, overruling Golok Nath, but cannot destroy the basic structure. Option 1 describes Golok Nath, which was overruled by Kesavananda. Option 3 is wrong because Minerva Mills applied and extended the doctrine, but did not create it. Option 4 describes the first application of the doctrine after it was established in Kesavananda.